Professor Getty.
Yes, good morning, everyone. I know some of you I'm not as familiar with. My name is Michel Getty. I am Professor Getty to a few of the members of the committee, or have been. I'm not anymore. But I'm currently serving as the Deputy Solicitor General for the state of Louisiana. I was a professor of criminal law, procedure, evidence, and a few other things for 24 years now. I'm on leave from Southern, so anything I'm saying today is not said on behalf of Southern. In addition to teaching the course, and I want to stop just for a minute and say, in teaching my criminal procedure courses, I teach both the constitutional side of it and also the trial procedure side of it. And my materials for the trial procedure side that I wrote myself are called Anatomy of a Murder Trial. So it goes from soup to nuts in trying a murder case. And in both of those sets of materials are the cases that we heard from the surviving families today. And I've read those cases over and over and over, and I don't know if some of my former students may remember reading it. The Code case in particular sticks out to me. And it was horrifying, and it's horrifying even for my students to read in black and white about the cases, but to hear the testimony of the victims today was a whole new level to that. And I just want to say thank you so much to these families for coming down here and exposing themselves to this, which had to be extremely nerve-wracking for them to sit before all of you with cameras and everything else that goes on. And I really commend them, and I hope you do too, for taking time and traveling and putting themselves through reliving the crime, as this lady back here had to do one more time after 20 or 30 years, to tell you their story, their personal story, and tell it to you in person. So in addition to teaching and making my own materials, I have also helped write the bench book that all of the judges throughout the state use to try death penalty cases. Also wrote the bench book for regular criminal cases too. But I also speak, I did that with, or through the Louisiana District Judges Association and the Judicial College. And I also present annually to the Louisiana Judicial College, to the judges, an annual update on all of criminal law and procedure, but including the death penalty cases. And in some years, we've had specifically just death penalty presentations for the judges throughout the state. So I continue to be involved in that. I also serve on the Law Institute's Committee on Criminal Procedure and Evidence, and have for 24, 25 years now. And I will tell you, just while I'm thinking of it with that the Law Institute, I think, will be having this session before you a rewrite of the post-conviction procedures in non-death penalty cases, and we are currently working on rewriting the post-conviction procedures in death penalty cases, which maybe hopefully will give some relief and reduce some of the time that it takes for these cases to go from conviction to execution. I also served for a year as a fellow to the United States Supreme Court back in 2012, 2013, and worked with the court up in Washington, D.C. during that time. I've also kind of maybe on the other side, I'm not sure where this falls, but I served for 6 to 7 years on the United States Commission on Civil Rights. Each state has an advisory committee, and I served on Louisiana's advisory committee to the U.S. Commission on Civil Rights for 6 to 7 years. I also served on the Louisiana Indigent Defense Assistance Board for 7 years. So I think I come at it from a number of different perspectives and all sides of the problem, and try to work with defense and prosecution, or have over the years. I'm not sure I can do that as much in my current position, but I have over the years. But in addition to that, I also always have to mention that I bring another perspective, and that's as a surviving family member of the murder of 2 little girls, a little 6 and 9-year-old little girls who are my daughters, 2 sisters. Some of you may be familiar. She came with me to the Senate to testify 2 years ago about the death penalty on Senator Claytor's bill. So if you're interested, I'm sure you can find the video of that and see both her and my testimony as to what a child who is the daughter of a murderer and also the sister of two victims goes through with this. These two little girls were murdered in Texas in 2001 by their dad, who was my former husband and my daughter's father. They were murdered in May of 2001. I have a different story to tell, though, than the other three victims' families who testified, because if you could use the word luck, luckily, our murder happened in Texas. It took 17 years, but the little girl's dad, who murdered them while their mom listened on the phone, by the way, was executed last February 1st, 2018. That wouldn't happen here in Louisiana. If the crime had happened in Louisiana, we would still be living with that. And you've heard their stories. I'm not going to go into detail. I'm not here to tell my story, but 17 years of waiting is a long time. And in the last few years of this just sitting on the bed when you have a warrant of execution for your dad, and waiting to find out, and then learning through Facebook that the execution was stayed, and then having it reset, and then sitting through that as the daughter of the man and having it stayed one more time, and then finally having your father executed. What I can tell you is, and people ask this question, and I know it varies with different victims, and I wouldn't know how it would have affected my daughter, but both of her sisters' birthdays are in January, and so that's kind of been that trigger every year, so to speak, for her to kind of fall off the edge and go into some depression or anxiety or whatever. January's never a good month for her. This year, a year later, I called, of course, and, how are you doing? Just thinking about you. And she said, you know what? I'm okay. I'm surprised to say this, but you kept telling me there would be closure, and I didn't believe you. But there's closure, and I feel peace that I've not felt for 17 years. So for those people that say that this does not give you closure, I can only tell you my personal anecdotal story. It does. It's given us both closure. So move away from me. I want to go on. I'm not really here for that, but it's important, I think, for you to understand my full perspective on the death penalty. What I wanted to do, and I was asked to come today, was really to put on my academic hat and give you the law that surrounds the death penalty and where it stands today. And as I prepared yesterday to do this, I kind of thought, I could sit here and tell you stuff, but I thought it would be better or maybe more persuasive if you really hear it from Justice Alito and Justice Roberts, who have recently written opinions on this. So the Gloss decision was in 2015. That's the most recent direct death penalty execution protocol decision by the United States Supreme Court, and that was in 2015, as I said before. And it's basically applying a case known as Bays versus Reese, which was decided by the court in 2008, specifically on the three-drug protocol that Louisiana currently has in place. This case, the Glossop case, also related to that three-drug protocol. So I'm not going to read specifically from the case. I'm going to kind of jump through it, but it gives, I think, a quick history and shows you where the United States Supreme Court stands today, which, by the way, is the governing court of our country, not the district court here in Baton Rouge that currently has a suit pending before it. So according to Justice Alito, often quoting from Justice Roberts' opinion in Bays, the death penalty was an accepted punishment at the time of the adoption of the Constitution and the Bill of Rights. In that era, death sentences were carried out by hanging. Hanging remained the standard method of execution through much of the 19th century, but that began to change in the century's later years. In the 1880s, the state of New York appointed a commission to find the most humane and practical method of execution. The commission recommended electrocution. It was in the late 1880s. In 1888, the legislature adopted that method, and in subsequent years, the other states followed, in the belief that electrocution is less painful and more humane than hanging. In 1921, the Nevada legislature adopted another new method of execution, lethal gas, after concluding that this was the most humane manner known to modern science. And again, these are Justice Alito's words. Nevertheless, hanging and the firing squad were retained in some states. For example, Delaware had hanging, Kansas had hanging, and Utah had hanging or the firing squad. Utah continues to have the firing squad today, as does the federal government. So electrocution remained the predominant method of execution until the 9-year hiatus in executions that ended in the 1970s with the case of Gregg versus Georgia. After Gregg reaffirmed that the death penalty does not violate the Constitution, some states once again sought a more humane way to carry out death sentences. And you know, some people misunderstand this, but the death penalty itself has never been declared to be unconstitutional. The cases in the early 70s on the issue declared a statute that had certain procedures leading up to the death penalty to be unconstitutional. States then had to go amend their statutes to comply with the court's rules. Once those statutes, the procedural aspect of the statutes were amended, the court in Gregg said that, again, reaffirmed, as Justice Alito says, that the death penalty is constitutional. Eventually, finding a more humane way to carry out death sentences, they eventually adopted lethal injection, which today is by far the most prevalent method of execution in the United States. I think handed out to you was a handout that looked something like this. This sets out the executions over the last 4 or 5 years, the method of the execution and where it took place. Which I will come back to, but it still continues to be the most predominant method. The protocol that was in the Glossop case that is still somewhat, but a little changed protocol. Back in 2008, the protocol that called for the 3 drugs, which were sodium thiopental, which was a fast-acting barbiturate sedative that induces a deep coma-like unconsciousness when given in the amounts used for lethal injection. The second drug is a paralytic agent, which inhibits all musculoskeletal movements and by paralyzing the diaphragm stops respiration. And number 3, potassium chloride, which interferes with the electrical signals that stimulate the contractions of the heart, inducing cardiac arrest, which is the cause of death. So were you to look at a death certificate for someone who was executed on death row by lethal injection, the cause of death would be the stoppage of the heart or heart attack or however they coined it on the particular certificate. At least 30 of the 36 states that used lethal injection employed that particular 3-drug protocol. That was in 2008. While methods of execution have changed over the years, this court has never invalidated a state's chosen procedure for carrying out a sentence of death as the infliction of cruel and unusual punishment. And I'm going to repeat that because the court continues to repeat that, sometimes in the majority opinion, sometimes the dissent complains about the fact that the court has stated this, but the truth is the court has never overruled or set aside a case based on the execution method that was used by the state. Never. In Wilkerson versus Utah, the court upheld a sentence of death by firing squad. And I would just suggest, because I may not get to it, that Justice Sotomayor, in a dissent to a denial of a stay recently, suggested that the firing squad may be the most humane method of execution today. And I may be able to get to that, but I don't want to take up too much time. In In re Kimler, the court rejected a challenge to the use of the electric chair and upheld the use of the electric chair as a method. And then again in Bays, the court specifically upheld the use of this 3-drug protocol, and it was again upheld in 2015, this 3-drug protocol that we have. Let's see. Our decisions in this area have been animated in part by the recognition that, and this is the whole policy and theory behind the majority of the court right now, because it is settled that capital punishment is constitutional, it necessarily follows that there must be a constitutional means of carrying it out. And that's where all of the reasoning of the court's decisions come from. We have held the death penalty is constitutional, therefore there must be a means by which it is carried out. Because some risk of pain is inherent in any method of execution, we have held that the Constitution does not require the avoidance of all risk of pain. After all, while most humans wish to die a painless death, many do not have that good fortune, and obviously the victims of these crimes did not have that good fortune. Holding that the Eighth Amendment demands the elimination of essentially all risk of pain would effectively outlaw the death penalty altogether, which it has been suggested by some of the justices in the majority that that is what the dissenting justices are attempting to do. But after Bays versus Reeves, a practical obstacle soon emerged as anti-death penalty advocates pressured pharmaceutical companies to refuse to supply the drugs used to carry out death sentences. The sole American manufacturer of sodium thiopental, the first drug used in the standard 3-drug protocol, was persuaded to cease production of the drug. After suspending domestic production in 2009, and the dates are relevant because I know some of you have questions about why haven't we executed anyone since 2010, so that's why these dates are important. So it was in 2009 that the American manufacturer of the first drug used in the 3-drug protocol quit producing the drug for purposes of execution. So it stopped the domestic production. Activists then pressured both the company and the Italian government to stop the sale of sodium thiopental for use in lethal injections, and the Italian government followed suit. So that particular drug, sodium thiopental, became unavailable for use. That effort proved successful, and in January 2011, the company announced that it would exit the sodium thiopental market entirely, thus created the problem that we had in Louisiana, because that was the drug that we were using at the time, and we couldn't get access to it and didn't really know what else to do at the time, although that was 9 years ago. After other efforts to procure sodium thiopental proved unsuccessful, states sought an alternative, and they eventually replaced sodium thiopental with pentobarbital, another barbiturate. And if you look again on this handout that you should have, you'll see pentobarbital is the drug of choice today, and is most predominantly used. And I again can tell you personally, that was the drug that was used to execute my former husband, and I might say unfortunately he died a very peaceful death. His last words were, "I don't feel anything, ah, there it is, ah," and then he passed away. And the mother of the 2 girls, who had, by the way, pledged on their grave in front of everyone, "I will go to my grave to get justice for you. I promise you I will get justice for you." And she stood at the window in the execution chamber to be sure that she got justice for her 2 little girls, who were 6 and 9. I don't know if I mentioned that. So anyway, we had pentobarbital. In December 2010, Oklahoma became the first state to execute an inmate using pentobarbital. By the way, it's used all by itself now, and by some. Some states use it as the first drug. Most states now are using it by itself. That execution occurred without incident, and states gradually shifted to pentobarbital as their supplies of sodium thiopental ran out. It is reported that pentobarbital was used in all of the 43 executions carried out in 2012. Petitioners concede, in other words, the defendants concede, that pentobarbital, like sodium thiopental, can reliably induce and maintain a coma-like state that renders a person insensate to pain caused by administration of the 2nd and 3rd drugs in the protocol. Courts across the country have held that the use of pentobarbital in executions does not violate the 8th Amendment. Before long, however, pentobarbital also became unavailable. Anti-death penalty advocates lobbied the Danish manufacturer of the drug to stop selling it for use in executions. That manufacturer opposed the death penalty and took steps to block the shipment of pentobarbital for use in executions in the United States. Oklahoma eventually became unable to acquire the drug through any means. The district court below found that both sodium thiopental and pentobarbital are now unavailable. Glossop came from the state of Oklahoma. So unable to acquire either of these drugs, some states have turned to midazolam. All right, midazolam is what we currently, I believe, are thinking of using. So midazolam is a sedative in the benzodiazepine family of drugs. In October 2013, Florida became the first state to use midazolam. To date, Florida has conducted 11 executions, to date being in 2015, has conducted 11 executions using that protocol, which calls for midazolam followed by a paralytic agent and potassium chloride. In 2014, Oklahoma also substituted midazolam for pentobarbital as part of its 3-drug protocol. Oklahoma, as of 2015, had already used the 3-drug protocol twice, and this is where the controversy came. So they used it to execute a man by the name of Clayton Lockett in April 2014, and a man by the name of Charles Warner, who was one of the initial petitioners in the Glossop case, in January of 2015. Again, these are Alito's words. The Lockett execution caused Oklahoma to implement new safety precautions as part of its lethal injection protocol. When they executed Mr. Lockett, their protocol called for 100 milligrams of midazolam to be used, as compared to 500 milligrams, which is what is currently required, the 500 milligrams. But in this case, the Lockett case, which you'll hear from anti-death penalty advocates about quite often, they had only used 100 milligrams. Not only that, but Mr. Lockett, the morning before he was to be executed, had cut his arms right at the bend of the arm in the elbow, so they could not use his veins in his arms to run the 3-drug protocol into his body. So they ended up finding one of his femoral arteries, in the groin area of your body, to run the line to use the drugs into. And so in order to maintain his dignity, they had placed a sheet over the area, because there are people that view the execution taking place, and they placed a sheet over that area. He started writhing, and he could still talk, and it was obvious he could still feel the pain. They quickly removed the sheet to see what had gone wrong, and the catheter had come out of the vein, and it was dispersing into his body instead of it directly into the vein. So you had two issues that don't happen often. One was that they used 100, and now they're using 500, and also that in this particular case, because he has self-mutilated, they could not use his normal veins, and they went in through the femoral artery and they couldn't see it and had not monitored it. So it was a little different circumstance than normally happens, but it caused disturbance throughout the community. He still passed away. It took about 10 minutes. He passed away 10 minutes later. Let's see, so I'm going to skip over that. Again, after Oklahoma switched from pentobarbital to midazolam, executed Lockett, 21 other death row inmates filed an action that led to this suit. Again, the 4 people that were involved, they filed for a preliminary injunction, committed egregious crimes, which are set forth therein. So that kind of gives you some background on the development and what has happened with the drugs, the 3-drug protocol, the use of midazolam, the failure of it to work effectively in the Lockett case, and I believe there are 2 other cases that there have been other problems with about the same time before the protocols have changed. Since that time, though, if you would look at this for just a minute, this is what I can tell you. In 2018, there were 25 executions. 14 of those used only pentobarbital. There are 2 that they weren't sure, but likely used that. There were 6 executions that used the 3-drug protocol, 1 execution that used the 4-drug protocol, which included, interestingly, the use of diazepam with fentanyl. And we're all hearing about fentanyl today, but I can guarantee, we know fentanyl kills. We know an overdose of fentanyl kills. So 1 state at least is currently using fentanyl for their executions. I believe, I could look real quick. That is Nebraska. Right, Nebraska is using fentanyl. But you can go through these cases and see the number of executions where midazolam was used. Now, Florida not wanting to stop the executions, also did research, and they have changed from midazolam to, and I'm probably slaughtering the names of these drugs, definitely have no pharmaceutical background, but they use etomidate, I think is the way you pronounce it, but they've used that for 2 years without a problem. And they have had, I don't know if I have the numbers directly, but I think there's 3 and 2, from 3 in 2018 and 2 in 2017, where that drug was used. In 2017, you had 23 executions, 9 used pentobarbital, 14 used the 3 drug, again with Florida using etomidate, or however that's pronounced. Amidate is the name for it. Other states have also used or looked into using propofol, which you may have heard of. That's a commonly used drug for surgery in that. And thiopental is another commonly used drug that can be used for these purposes. The amidate that Florida is using it's used in emergency rooms predominantly, and it causes a very fast onset of action. It takes maybe 30 to 60 seconds to take effect. Now, at the normal dosage that's given in an emergency room, it only lasts for 5 to 10 minutes, but a normal dosage is not used in execution, so that it lasts longer than that. In 2016, we had 20 executions around the country. 3 used the 3 drug protocol, and 17 used pentobarbital. In 2015, we had 28 executions, 26 with pentobarbital, and 2 that used the 3 drug. In both years, those were using midazolam. So midazolam has been used effectively in all these states for all these years. Whether or not we can access it or not, I don't know. I would also tell you that Texas, for example, has begun to compound its own drugs since it couldn't get it. Something that's very easy to do and would be quite easy and effective. And they've been using their own compounded drug, despite some defendants raising the question of experimentation or whatever. The court has denied all writs on that and not accepted any challenge to the use of, or to the state compounding its own drugs for execution purposes. Alabama last year passed a law to use, I'm not going to say this right, but basically a gas. And they had, right after they passed that law, they had 8 death penalty or death row inmates request to be executed through the use of the gas that they were going to use. They have not yet done that, but in fact, a lawsuit that these inmates had filed was dismissed by agreement because they basically agreed, although I know they'll contest it later, that they would choose to be executed through the use of the gas that's being used. So that's another alternative that's there and that has been upheld. Actually, in one of the cases that the court denied writs in and that Justice Sotomayor descended to out of Tennessee, just a few days after the court denied the stay, the man was electrocuted. So they went back to using the electric chair in that case, although that wasn't argued before the court. Basically, the rule today at the Supreme Court level is that the defendant has to come in and show that the method that the state is going to use would cause, a risk that is sure or very likely to cause serious illness and needless suffering and give rise to sufficiently imminent dangers. To prevail, there must be a substantial risk of serious harm, an objectively intolerable risk of harm that prevents prison officials from pleading that they were subjectively blameless for purposes of the Eighth Amendment. This is from Bays versus Reese. The prisoners cannot successfully challenge a state's method of execution merely by showing a slightly or marginally safe alternative. Instead, prisoners must identify an alternative that is feasible, readily implemented, and in fact significantly reduces a substantial risk of severe pain. So they have to both show that the current method causes severe pain and suffering, and also that there is an alternative that the state could use that would cause less pain than that, and it can't just be a hypothetical alternative to be shown. And that's what it would take for any of these people who are on death row to go pass the district court here and prove that whatever method Louisiana chooses to use would be unconstitutional. And there's not ever been a case that the Supreme Court has found that to be true, nor is there a case where the Fifth Circuit has proved that to be true. And I have here the Fifth Circuit recent, just the last 3 years, Fifth Circuit opinions upholding both Texas and Mississippi's use of these 3 drug protocols and the pentobarbital protocol as being constitutionally acceptable. So there's nothing in terms of law, Supreme Court or Fifth Circuit law, that would keep Louisiana from moving forward with what we have. There's also many other alternatives that can be used for execution purposes, almost all of which have been upheld in one form or another at the circuit level, and not specifically by the Supreme Court, but has been upheld by denial of stay and denial of writs in those cases, with, hearty dissents by Justice Sotomayor in particular, and occasionally Justice Breyer. So we're set to be able to move forward if that's what Louisiana wants to do. In terms of any suggestions that I might have, again, Texas and Tennessee that I'm aware of, and I have the statutes with me, passed these privacy laws. Now we had, I think it was Representative Peeland, if I'm not mistaken, in 2014, presented such a law to us. Ironically, it didn't get through. It looked like it died one of those end of the whole session deaths in the House on the floor. But in the following years, when Texas enacted theirs, it's been upheld by the Fifth Circuit against secrecy challenges, due process challenges by defendants. But the way it came about is that one of the compounding companies in Texas that were providing the drugs voluntarily, and they knew what they were to be used for, but through the defendants, the name of the company leaked out. And then they got a lot of bad publicity, and they were not happy, and they were upset. And so the law was passed to protect the compounding people and the manufacturers of the drugs in that, because that's been the problem in the past. It's been bad publicity and lobbying against the companies in that. Louisiana could very easily pass that law. There's 2 or 3 of them already in place in other states. We have one almost that was ready to go in 2014. That would provide protection to companies and make the availability of the drugs and of compounders more readily available to the state. The law in Louisiana simply says lethal injection. That's all the current law says. It's up to the administration, the Department of Corrections in particular, to decide administratively what protocol is going to be used, what drug is going to be used, what procedures are going to be used. That's something that's up to them. Arguably, the pharmacy board could have some say in it in terms of if they wanted to, making it easier or more difficult in that regard to compound the drugs. But we can get the drugs. States all around the country have the drugs, are getting the drugs, or they're making their own. And one other thing I would mention that you may find interesting, there is a parallel problem, air quoting problem going on, which you may not have thought about. But I'm sure you've heard of physician-assisted suicide. So those states, which are Washington, Oregon, California, and there's Montana, I think I want to say, and there's one more. There's 5 states now that have enacted laws for physician-assisted suicide, or euthanasia, as some other people might refer to it. They use the exact same drugs that we're talking about for execution. It's the same drugs, which are supposed to be a good thing for those people who want to end their lives. And they're supposed to be not horrible, like they're being called when they're used for executions. They're also having problems finding those drugs. One of the companies we've had to deal with bought up one of the other companies that provides the drugs, and then spiked the price of the drug up to like $3,000 a dose, and priced it out of reach for a lot of people that wanted to commit suicide or physician-assisted suicide. But the same problems are there. It's the same drugs. It's considered to be humane for physician-assisted suicide, at least in those 5 states. And they're also now compounding their own drugs for that use. I'm sure I'm leaving something out, but if any of you have any questions, I did want to mention one of the other handouts, and if we have extra copies, I'd be happy for the families to have a copy of this. But this is the current death row, so it's like welcome to death row, and I really encourage each of you. I know you don't have time right this minute, but to take the time to read through who we have on death row and what they have done to those victims in their crimes, because none of these are run-of-the-mill crimes, right? I mean, this is your grandmother, your 71-year-old grandmother, whose yard man came in and raped her and beat her and stabbed her to death, or the fire captain who, a home invasion again, and they tie up his mother, and she has to sit and watch, much as this woman had to, and listen as they tie up the son and kill him and set him on fire and then burn down the whole house. These are the children that were boiled to death or stabbed to death, or who one of them took the small child and bent the child in two to the point that it severed the spinal cord. This is who's on death row. But it's important that you guys understand, because it's easy when there's not a face to the victim or a face to the defendant for that matter, and you don't understand the kind of crimes that receive the death penalty these days, to maybe feel some sympathy or be persuaded by some of the arguments that are being made. But please take the time and look through and see what has happened. You can also notice when they were convicted, which is another important point on the executions and the number of the years that have passed. Most of the time, it doesn't take a long time to get the person convicted. It's done in a year or two, 3 or 4 at the most. The conviction is not the expense. And we'll talk about expense. It's not the conviction that's the expense. It's not obtaining the death penalty that's the expense to the state. The expense comes with the litigation that goes on and on and on and on. I can speak personally. We've got a number of cases at all different levels. And these are not cases where there's any question about whether the defendant was guilty or not. These are cases where, we've got 2. One that was just reversed by the Supreme Court, the McCoy case, which is in here, that was reversed because the attorney supposedly was ineffective. And this is another thing to understand. The attorney was ineffective for trying to save his client's life, right? The client, and many of them today are doing this. They want to be tried for the death penalty as opposed to a life sentence. They won't agree to a life sentence, many of them, because they know that if they are convicted with the death penalty, it's going to be 15, 20, 30 years before they're executed, if at all, because of all the more the attention that's paid. They get 2 attorneys, they get to go through all the way to the state, up to the top, all the way to the Supreme Court, back down again through post-conviction in the state, all the way to the top to the Supreme Court, back down again to the federal district court habeas, all the way through the federal courts to the top before they ever going to be executed. And so they choose to get the death penalty instead of a life sentence. And they tell their attorneys, do not say anything that would get me a life sentence. I don't want you to argue for a life sentence. And in McCoy, the Supreme Court said, if your client tells you that you can't argue to get you a life sentence, then you can't do that. And that case was reversed for that reason. And we've got one that was remanded by the Supreme Court back to the Louisiana Supreme Court that's being argued in next week or the week after that for the same reason. So these are not questions of innocence. These are questions of procedure.